So Mr. Christofides is head of the regulatory group of the Papafilippou & Company LLC and a member of the corporate and commercial practice group. He has extensive experience advising domestic and international clients, including New York Stock Exchange and NASDAQ listed companies. And his wealth of knowledge covers matters of EU law, protection of competition law, concentration, control law, international private and public law, anti-money laundering, human rights law, and data projection. So, Mr. Christofides, please, the floor is yours.
Dear friends, good afternoon. Thank you very much, Andrea. Further to the most insightful presentations delivered during this masterclass, first of all, let me thank CIIM, SIMBA, and ILA Cyprus branch for the opportunity to present a number of indicative, I have to stress it, indicative issues pertaining to the application of the EU FDIS regulation and the Republic of Cyprus legal order. As it is known, currently there is no legislation enacted by the House of Representatives concerning foreign direct investment screening, known with the acronym FDIS in general, and EU FDIS regulation in particular, whilst no notification has been filed with the EU Commission under Article 3.7 of the regulation regarding the introduction of a screening mechanism or an amendment thereof. Accordingly, it is anticipated that the Republic will initiate in the near future the legislative process via public consultation with the participation of stakeholders, that being interested parties affected by the introduction of such legislation. The absence of EU FDIS regulation-related legislation in the Republic could indeed raise queries as to the legality of the materialization of a proposed investment in both the Republic and other EU member states, where EU FDIS regulation-related legislation is currently in force, such as in Germany, France, the Netherlands, Austria, and for the time being UK, especially in view of the Article 6.1 regulation reporting requirement. As to the security and public policy concepts under the EU FDIS regulation, Article 4.1 of the regulation requires EU member states and the EU Commission to consider whether a foreign direct investment is likely to affect security or public order, giving rise to an EU-wide element of appraisal, and not merely the obligation to consider the concepts of security and public policy within the narrower margins article of this year, 2020, by Nicole Koenig, entitled "The EU Strategic Compass for Security and Defense, Just Another Paper."
Pantelis,
yes.
It seems we had a bit of a streaming issue in the last 10 seconds. So could you backtrack a bit and take us through the last 10 seconds of your...
Definitely. So as to the security and public policy concept under the EU FDIS regulation, Article 4.1 of the regulation requires EU member states and the Commission to consider whether a foreign direct investment is likely to affect security or public order, giving rise to an EU-wide element of appraisal and not merely to the obligation to consider the said concepts within the narrower margins of the legal order of each member state. Regarding the lack of uniform application as to the boundaries of the interpretation of the concept of security and public policy across EU member states, reference could be made to a very interesting 2020 article by Nicole Koenig entitled "The EU Strategic Compass for Security and Defense, Just Another Paper." The interoperability of the application of the said concepts by each member state with the application of Article 6.1 of the regulation cooperation mechanism and reporting requirement could give rise to frictions as between member states themselves as well as between the member states and the EU Commission. Such disagreements, put it mildly, could become more evident in light of the power of the EU Commission to issue an opinion and the entitlement of each EU member state to provide comments under Article 6, paragraphs 3, 6, and 7 of the EU FDIS regulation. Although such an EU Commission opinion or EU member states' comments are not binding on the relevant EU member states, one could anticipate interaction with the rule of law principle and potential initiation of proceedings against such a member state under Article 7 of the TEU of the Treaty of the European Union. Shield's 2019 article could provide a further insight on this. One cannot also disregard the possibility that the national parliament of another member state could urge the EU Commission via the adoption of a resolution to initiate rule of law proceedings. By a way of analogy, the relevant resolution of the lower house of the Dutch parliament of 1st December 2020, obliging the Dutch government to file a claim against Poland and CJEU for disrespecting the rule of law, could be shedding some light in that respect. Regarding the scope of categories of investment under screening obligation, Article 4.1 of the EU FDIS regulation provides an indicative, though not exhaustive, list of investment categories. The member states can exceed the minimum obligations laid down by the regulation. For example, the German Federal Ministry of Economics and Energy can proceed with screening of any economic sector, taking into account the intended acquisition of at least 10% or 25% of the voting rights, with mandatory notification being applicable only in relation to specified sectors. The French Ministry of Economy and Finance, FDI Screening Unit, reviews intended investment by any natural person and or legal person with what it is called a foreign element, with 25% shares and or voting rights threshold in an asset or a line of business which carry out specified activities such as defense, energy, transport, health, electronic communications, critical technologies, and other sectors. Land and real estate intended acquisition review is mandatory under the EU FDI's regulation, but only when related to critical infrastructure, whether physical or virtual, including energy, transport, water, health, communications, media, data processing or storage, aerospace, defense, electoral or financial infrastructure, and sensitive facilities. To put it simply, in the event that a foreign investor will be wishing to purchase plots of land, parcels of land, near an area which could be utilized for the construction of a port or an airport or even a hospital, that will qualify. And mandatory investment screening will ensue. Further, a member state is entitled to enact into legislation a voluntary disclosure provision encouraging potential investors to submit a notification even if a transaction does not involve a listed sector, but may still have a security or public order element. This is the case under Section 18 of the UK National Security and Investment Bill. Regarding the potential nature of the national screening body of the Republic of Cyprus, this could be either an independent administrative body or a department of a competent ministry of the Republic. Regarding the potential scope of information disclosure by foreign investor, this could indeed envisage ultimate beneficial owners information, including source of funds and activities, corporate information regarding legal entities, including information as to the directors thereof, proposed investment information, as well as an impact assessment report on the economy, not only of the Republic of Cyprus, as well as of the EU. The scope of information disclosure by a potential investor, whether Cypriot or originated from another EU member state, must also be assessed, along, of course, with the possibility of introducing a pre-notification consultation process as between a foreign investor and a national screening body, as is the case in France, which could offer to potential investors a greater degree of legal certainty as well as of predictability. Moving along the same lines, the Republic of Cyprus could legislate the ability of the national screening body to request clarifications or to hold oral hearings during the screening process to a foreign investor, as well as the ability to discuss potential investment structural remedies so as to address security or public policy concerns, or even the imposition of conditions akin to the Republic of Cyprus control of concentrations between undertakings law of 2014. Regarding the interplay with competition law, which has been correctly marked by Nikitas and Chris earlier, one could also seek guidance as to the preamble, as to the interpretation of preambles 36 and 37 of the EU FDI's regulation. As to the screening timeframe now, the optimum potential scenario which could be realized will be to achieve synchronicity with the Republic of Cyprus Concentration Control Law, which is supervised by the Commission for the Protection of Competition, CPC, as follows. Under phase 1, a decision of non-opposition will be expected within 1 calendar month from the date of receipt of the notification from the national screening body, or as the case may be, from the date on which the national screening body receives the additional information which is necessary for securing compliance of the notification requirements, extended by 14 calendar days, depending on the complexity of each case. Under phase 2, a decision for conduct of further investigation, which may result to a negative decision, or the imposition of conditions, or as these are called investment structural remedies, will be expected within 4 calendar months from the date of receipt of the notification from the national screening body, or as the case may be, from the date on which the national screening body receives the additional information which is necessary for securing compliance of the notification requirements. Indicatively, it is noted that the screening timeframe in France is 30 working days maximum regarding phase 1, and a maximum of 45 working days regarding phase 2. Factors which could influence the screening timeframe include the effectiveness of pre-notification consultation process, resources and personnel to be dedicated by the Republic of Cyprus to the national screening body, potential usage of blockchain technology, and of course, the EU FDIS national law level of knowledge of potential foreign investors and Cyprus legal community. The potential outcomes of the notification process could include a notice informing the notifying parties that they can proceed with the proposed investment, as the said proposed investment does not fall within the scope of the national law. Secondly, a notice granting authorization to the notifying parties on the grounds that the proposed investment does not give rise to concerns under national law. Thirdly, a notice granting authorization to the notifying parties to proceed with the proposed investment, however, subject to specific conditions, such as divestment of specific segments of the proposed investment, and/or continuing reporting obligation to competent ROC governmental departments during the proposed investment implementation, in accordance with the EU and Republic of Cyprus legal principles, including the principle of legal certainty, proportionality, and non-discrimination. It is noted that the concept of imposition of conditions is highlighted at the EU FDIS regulation preamble, recital 22, as well as in Article 2.4. A notice of objection regarding the materialization of the proposed investment could be the fourth outcome, but solely on grounds of security or public policy, such as the inclusion of a notifying party in EU and/or UN sanctions list, or where the imposition of conditions will not be appropriate or sufficient so as to address a real threat to the security or public policy. Sanctions regarding a failure of investors to submit a mandatory notification and implementing a proposed investment prior to an authorization notice could include penalties of either criminal or administrative nature, such as fines, including a fixed fine for failure to file a mandatory notification and a daily fine for each day of infringement, issuance of an injunction prohibiting the materialization of specified activities, issuance of an order invalidating the investment, or in the alternative, inclusion of a legislative provision rendering an investment concluded in violation of the national FTIS law invalid from the outset, as is the case under the protection of competition laws of the Republic. Fourthly, an issuance of an investment divestment order. And fifthly, the publication of sanctions imposed on the notifying parties in the website of the national screening body, as well as in the official gazette of the Republic of Cyprus as a deterrence measure. It is anticipated under the Republic of Cyprus legal order that the notifying parties will have the right to initiate judicial review proceedings, in Greek prosphygii, before the Administrative Court of Cyprus, potentially with an application concerning a request for a preliminary ruling under Article 267 of the Treaty on the Functioning of the European Union, as well as an application for the issuance of an interim order of injunctive nature concerning the national screening body's decision, either as to the notice of objection or as to the notice of authorization, subject to the fulfillment of specific conditions. Third country investors could potentially bring a claim under Article 63 of the TFEU regarding undue restriction of capital movement in accordance with the conditions set out by the CJEU case law, and the CJEU judgment in Kronos could provide guidance to that effect. The notifying parties could be afforded with the right to have access to the national screening body's administrative file of the notification process by filing a relevant application before the administrative court and taking into account Article 41(2)(b) of the Charter of Fundamental Rights of the European Union as to the aspect of the right to good administration, as well as under the Republic of Cyprus law regulating the right of access to information of public sector of 2017, which enters into effect on 22nd of December 2020. Potentially, there is a right of the notifying parties to have access to the EU Commission's administrative file regarding the notified investment under Article 42 of the Charter, which provides that any citizen of the Union and any natural or legal person residing or having its registered office in a member state has a right of access to documents of the institutions, bodies, offices, and agencies of the Union, whatever their medium. There are arguments in favor of the notifying parties being granted access to information pertaining to the comments submitted by other EU member states regarding the notification. To that effect, one could argue for the mutatis mutandis, by analogy, application of the CJEU recent judgment in RNNS and KA with reference to Article 47 of the Charter on the right to an effective remedy and to a fair trial. The gravity of the consequences from the application of the EU FTIS regulation on potential investors could be mitigated by the insertion of contractual clauses as conditions precedent within the text of the contractual agreement between the said investors, envisaging, amongst others, firstly, obtaining notice of authorization without conditions or without envisaged foreseen in the contractual agreement's text conditions, prior to proceeding with closing of the contractual agreement and materialization of the proposed investment. Imposing a duty on both parties to the contractual agreement to cooperate and provide all information documentation required under the national FTIS law and the EU FTIS regulation regarding the notification and the assessment thereof by the national screening body. And thirdly, installing a monitoring and appraisal mechanism as between the contractual parties regarding firstly the progress of the said notification procedure, as well as the appraisal of the end result, the decision of the national body. The dynamic nature of the FTIS legal regime is evidenced by the need to reevaluate the scope and effectiveness of such prospective EU FDIS regulation-related national legislation in light of the developments connected with the aforesaid EU Commission white paper on leveling the playing field as regards foreign subsidies. Accordingly, concerning potential investors, as well as indeed the economy of the Republic of Cyprus, this is definitely a legal space to watch. Thank you very much for your attention, and of course, I remain at your disposal for any queries.